Today I'm going to talk about a very common question that I've gotten over 20 plus year period of my career is talking about finders when it comes to raising capital. There's a lot of questions that surround this from clients. What can I do? What can't I do? What's going on? There's a finder's fee exception, a rule potentially with the SEC. There's an exemption in Texas and California. What does that mean? So I want to just go over a little bit about what is a finder and a little bit about the proposed rule because I'm hoping that with the new administration, since that proposed rule was put forward in 2020 and there was a new administration for 4 years, but now there's a different SEC chair and administration, maybe they'll actually push this forward. So instead of being a proposed rule, it will actually go into place. So that's what I'm hoping because I think it would alleviate a lot of questions and a lot of issues that people face raising capital. So let me share my screen real quick. All right, so finders. What do we do when someone wants to bring capital into a company? You're an entrepreneur, you are, whatever the case may be. You have a startup, you have an entrepreneur, you have an investment fund, you want to raise capital, and you've got somebody who says that I've got some investors and I want to bring them in, but I want to get paid. I don't just want to give up these names to you without getting something out of it. So how do we do that? And in the past, normally you have to be a registered broker dealer of securities. There's a very limited exceptions of ways we can try to go around that to where you can get paid compensation in some form for bringing investors in, but it gets a little more complicated in this video that I'm going to go over. But essentially, there's a number of factors the SEC looks at to see whether you're violating the restriction that says you have to be a registered broker dealer of securities. So we want to try to avoid that. Those factors, one of the biggest is transaction-based compensation. In other words, commission. Do I get a percentage of money I'm bringing in? Usually, you're not allowed to do that. So some of the legal issues, I'm not going to go over them in detail, but it's the Exchange Act of 1934, which primarily Section 15A deals with the requirement that you need to be a registered broker-dealer of securities. And essentially what it boils down to is when you go out and you raise money, whether it's for stock or interest in an LLC or whatever it is, telling the investor, put some money in, the investor is buying a security. They're buying, whether it's a debt, it's a promissory note, they're buying a share of stock, they're buying an interest in an LLC. Those are all securities that are covered under securities law. And normally you have to be a registered broker dealer of securities, which is a whole process to get that before you can actually go out and bring in investors and try to sell them a security and get paid commission for doing so. So there are companies and people who do this, including placement agents, but they're already registered broker dealers. One of the main concerns when it comes to raising capital is also a rescission right. If things are not done properly, your investors can get their money back. I'm not going to cover that in much detail here. But the only thing I would say is uh, a finder, basically, let's say that a finder, you go out and you raise capital and you don't do it legally. There's ways that potentially the sponsor of the deal could avoid payment on the finder's agreement because it's not a legally binding contract because it's not valid, because you had to be a registered broker dealer to enter into it. So potentially the sponsor could avoid having to pay the finder in some cases because it was an illegal contract. So an unregistered broker dealer under Section 15 of the Securities and Exchange Act, you have to be engaged in the business of effecting transactions in securities on behalf of someone else. So basically, that just means I'm going to go out, I'm going to bring in investors for investment fund A, and they're going to buy LP, limited partnership interests, which is a security in the fund, and I'm going to bring those investors in and get some kind of commission. So you're basically doing a transaction to help bring investors in. The finder can potentially be sanctioned or fined by the SEC. There's enforcement actions. One of the biggest factors that I mentioned is transaction-based compensation. The limited finder exception that I'm going to talk about, there's one in Texas and one in California. It's very limited, usually do like a single or very limited number of transactions. You have to register with the state. The main one I want to cover is the proposed rule with the SEC. I think this one would really help a lot if we can push it through. So the options for people raising money is how do you do this? You can avoid key factors in determining if someone is a broker dealer or using someone who actually is registered as a broker dealer. Now, the new SEC rule, now back in 1991, there was what's called a no action letter issued by the SEC. It was called In Re Paul Anka. Paul Anka, the entertainer back in California, had essentially come to someone and they had potential investors. And they said, hey, I will give you a list of investors for your deal if you pay me. And the SEC said, we're not going to take action against you. You didn't violate this restriction on the person being a registered broker dealer, but it's very limited. You have to have an agreement with the finder that says, all you're doing is giving me a name and a number of people you think are accredited investors. They have to be accredited that you have a pre-existing relationship with. And that's it. Just an intro. You are not involved in any other aspect. You don't negotiate. You don't sell them on the deal. You don't hype it up. You don't do anything. All you do is say, hey, John Smith and Jane Smith, I know you guys want to invest some money in real estate. Let me introduce you to a real estate fund. And that's it. And then you walk away. And in that case, in the Paul Anka no action letter, they said you could get a finder's fee for something as basic as this. Now, in 2020, there's a proposed rule, the exemptive order granting a conditional exemption from the broker-dealer registration requirements of Section 15A. And essentially what it does is breaks it down into tier one and tier two of types of finders. And it says if you follow this proposed rule, then you can get paid a commission to help people raise capital as a finder legally. Now, it's just a proposed rule. I want to be clear. It was proposed almost 5 years ago, and they asked for comments, and it's gone nowhere. So hopefully maybe the new administration will push to actually make this proposed rule go into effect. Once the SEC rules that it's declared effective, it gets published in the Federal Register and it becomes an actual rule a few months later. So we'll see if that actually happens, but let's say it does. What exactly does it say? So let me switch my screen to the actual tier one and tier two that the SEC prepared. And I will show you essentially what they say the difference is. Okay, so this is a slide from the SEC that talks about this proposed order that may go into effect. So you have registered broker-dealers on the far right and a check mark saying what they can and can't do, and this proposed safe harbor rule for tier one or tier two. And essentially the way to think about it is tier one is very basic introductions. Tier two is they're a little bit more involved in the actual transaction. And who, only natural person, so no legal entity, an LLC or a platform or anything, can't use this exemption. You have to be an individual. You can get transaction-based compensation, meaning you can get a commission just like a registered broker-dealer based on, hey, the most common is, okay, if I raise, X number of dollars, I want a percentage. I want 10% of the capital I raise. So if they raise $10 million, you cut them a check for $1 million for that money that they raised. This exception would allow you to do this. The investors have to be accredited. So just like under Regulation D, where you have 506C, where it talks about accredited investors only, the investors that the finder brings in, they have to believe that they are probably or most likely an accredited investor. You can't bring non-accredited investors in under the rule. The rule would only apply to private companies. And when it talks about reporting, that means publicly traded companies that are registered with the SEC would not be able to take advantage of this. But a huge amount of the capital is raised under Reg D, Rule 506, for private placements for private companies. So this would apply to those private companies. The types of offerings that you can get paid on, you can't get paid on follow-on offerings, IPOs, secondary sales, just a primary exempt offering, meaning the first offering, like a Reg D offering, like I talked about, a 506B B or C, where it's accredited investors only, you could get paid on that initial offering that they do for the company. And under tier one, which is the far left column here, is all you do is provide investor contact information. That's it. Like the Paul Anka letter, here's their name and their number. Boom, that's it. If you want to call them, call them. That's all you do. Now, under tier two, you can do more. You can identify, screen, and contact potential investors that you have a pre-existing relationship with. So you can reach out to your network and see if they might be interested. You can distribute offering materials under tier two, but not tier one. So you can take the PPM or other documents from the company raising money and distribute them to the potential investor. You can act as a go-between. You can talk a little bit about the issuer, the company raising money, and also set up meetings with the company raising money. So you're allowed to do a little bit more under tier two versus tier one. A registered broker dealer, you'll see all these other permitted activities. They can go out and solicit, they can handle funds, they can structure the terms of the offering, they can negotiate things, they can give an independent analysis of the actual, is this a good deal or not? Whereas the finder's fee exemption does not allow you to do that. All you can do, even on the most expansive tier two, is introduction, screen candidates, distribute the PPM and other offering materials, and talk about it a little bit with some meetings, and that's it. Under tier two, you are limited. I'm sorry, tier one exception. You can only do essentially one transaction per 12-month period. Under tier two, you can participate in more than one transaction in a 12-month period as a finder. So you can get paid more than once per year, just like a registered broker dealer. Some of the other common terms in a securities offering, the anti-fraud rules still apply, meaning if you act as a finder, both the company raising money and you as a finder can be prosecuted for fraud, civilly and criminally, if you make material misrepresentations. So if you start lying about the terms of the offering or misstating the potential of the company or what they're going to do, both the investor or regulatory agencies can come after you or the company raising money. You should have a written agreement under either tier one or tier two with the company raising money. And in here it says issuer. That's the issuer of the security. That means the company raising money. Written disclosure to investors is required under tier two, but not tier one. And part of that is tier one, you're not allowed to give them anything. All you do is make an introduction. So under tier two, you want a disclosure to investors that you're acting as a finder. And these are, whatever type of disclaimers we want to put in there for a disclosure. So that's basically kind of a quick overview of the different types of tier and it's an exemption that would be allowed. So as of right now, like I said, it's a proposed rule with the SEC. Hopefully, maybe in 2025, we can push it through and get this to be an actually enforced rule that would totally open up to where people would feel much more confident in acting as a finder and getting paid for it. Because, in over 20 years of practice, I've seen so many times where people, they know it's not technically legal, but they'll do it anyways because they need the money. They're trying to raise money. They're having a hard time. So they will go to, somebody's going to make an intro for a $20 million check and they want a little piece of the pie. So they'll figure out a way to make them get paid, even if they know that it's probably not legal. So it happens all the time, unfortunately. And this would really help things if this finder's proposed rule actually goes through.